A sitting president of the United States just had a federal judge look directly at his sworn testimony and call it false. Not misleading, not unclear, false, under penalty of perjury. And that judge, she didn't schedule a routine follow-up. She cleared her entire calendar midweek, dropped a 19-page order without warning, and then when Trump's own lead attorney tried to run, she said, no, you're staying right here. So before you scroll past this thinking it's just another political headline, just another back and forth, just more noise, stop, because this one is different. And I'm going to show you exactly why. Document by document, line by line, $127 million, 23 pages of sworn statements, and a paper trail so damaging that the people who helped build Trump's defense are now trying to escape before Thursday. Let's get into it. I've been reading these court filings since the moment they dropped Friday afternoon. Read through them 4 times now. 4, and every single time, the same thing jumps out. And the headlines aren't giving you the full picture. They're giving you the political version and the talking head version, the left versus right version. But the documents, the actual filed documents sitting in the public court record right now, they tell a different story. A story about sworn statements that don't match bank records, about signatures appearing on documents that the man who signed them now claims never involved him, about a federal judge who doesn't use phrases like deliberate misrepresentation by accident. Judges choose their words like surgeons choose their instruments, carefully, precisely, and with full knowledge of what those words are going to cut. So let me give you the real picture. Let me show you what's actually in these filings, because once you see it, you can't unsee it. Here's the quick background. Donald Trump, sitting president of the United States, is a defendant in a civil fraud case out of the Southern District of New York. And weeks ago, his legal team made a decision, a bold one. They submitted a 2-3-page sworn affidavit. Trump signed it under oath. The affidavit made one central argument. Trump had no direct involvement in certain real estate transactions. Subordinates handled them. He was hands-off, standard defense for a CEO of a large organization. Plausible, right? You've got a billion-dollar company, hundreds of employees, executives signing things on your behalf every day. It's a real argument. And for a little while, it looked like it might hold. Then the other side filed their response. And that's where everything changed. Attached to that response were 47 internal emails. 47. All of them produced by the Trump Organization itself during the discovery process, all of them authenticated by Trump's own legal team as genuine business records. And buried inside those emails, in a chain from October 2024, subject line, Lexington final terms, was Trump's own email address. In the CC line, 11 separate messages. And then in one thread, a response attributed directly to him. 3 words, just 3, approved, move forward. 3 words, $127 million. And an affidavit that says he knew nothing about it. Think about that for a second. Either Donald Trump forgot that he personally approved a $127 million transaction, which, let's be real, is not the kind of thing that slips your mind, or that sworn affidavit his team submitted to a federal court contains statements that are flatly, demonstrably, documentably false. There's no third door here. I went through this 3 times looking for one. It isn't there. And it doesn't stop with the emails. Not even close. Page 4 of the affidavit, Trump claims no involvement in loan negotiations. Exhibit 9 bites that the opposing side filed back Trump's own initials on the term sheet for those exact loan negotiations. Page 8, Trump claims he never communicated directly with the lender. Exhibit 11A, an email from Trump himself to the lender's CEO, discussing interest rates, direct communication, in writing, time-stamped it, authenticated, already in the court record before anyone even walked into a courtroom. Every denial in that affidavit has a document sitting right next to it saying the opposite. His own documents, produced by his own company, signed off as genuine by his own attorneys. Friday, March 6th, Judge Patricia Holloway issued a 19-page order, and she did not hold back the language she used. Troubling discrepancies, apparent contradiction, and then the one that should make everyone pay attention, potential sanctions. Judges don't write 19-page orders on a Friday afternoon because they're mildly curious. They write them because something is seriously wrong and they want it on the record immediately. But here's what didn't make the headlines. Paragraph 31, page 14, easy to miss, easy to skim past, you almost have to be looking for it. The filing alleges, and I want you to hear this clearly, that Trump's own attorneys were made aware of these contradictions before the affidavit was ever signed, that they flagged the issue internally, and that the affidavit was submitted anyway. Read that again, slowly. Because if that's true, and I want to be clear, that's a significant if. It's an allegation not yet proven. This doesn't just involve Trump. This potentially puts his entire legal team in the middle of submitting statements to a federal court that they had reason to believe were false. And that's not just a problem for Trump. That's a problem for every attorney whose name appears on those filings. And it's not just one person saying this. There's a document produced during discovery, an email dated October 29, 2024, from a Trump Organization vice president to an attorney on the defense team. The email asks, and I'm paraphrasing here because I'm not going to quote it verbatim, essentially, are we absolutely certain the president wants to state he had no knowledge of this? Because I have 3 signed authorizations sitting in my files right now. And the response from the attorney, same day, proceed as instructed, with full knowledge that there were signed authorizations that contradicted what they were about to swear under oath. That email is now part of the public court record. It exists. It's been authenticated. And on Thursday, someone in that courtroom is going to have to explain it. Now, let me pause here because I want to give you the other side fairly honestly. And here's the thing. Some of the defense arguments aren't crazy. They're actually worth taking seriously. Because if you don't understand them, you can't understand what Thursday's hearing really means. Trump's defenders make several arguments. First, the timing of this case. It targets a sitting president during his term in office. Judge Holloway was appointed by a Democratic president. The plaintiff's attorneys have donated to Democratic political campaigns. Is that proof of bias? No, but is it worth noting? Yes. Courts aren't supposed to be political. But courts are made of humans, and humans bring their histories with them. Second argument, corporate complexity. Think about what it actually means to run a multi-billion-dollar real estate organization with 340+ employees. Executives in organizations like that sign stacks of documents every single day. Documents prepared by subordinates. Documents summarizing deals that teams of people negotiated over months. Mike Davis, former chief counsel for nominations on the Senate Judiciary Committee, put it directly. Every CEO in America signs documents prepared by people below them. That's not fraud. That's how large organizations function. Holding an executive criminally responsible for every document bearing their signature without proof they personally understood every detail sets a terrifying precedent for corporate governance. Third, the legal standard for perjury is genuinely, seriously, extremely high. Even Judge Andrew Napolitano, who has been consistently critical of Trump on other legal matters, acknowledged this. Prosecutors don't pursue perjury lightly. They need ironclad proof of intentional, knowing falsehood, not carelessness, not delegation gone wrong. Deliberate, willful, lying under oath, that's the bar. And honestly, Trump's legal team filed a 3 one-page response Saturday night, yes, over the weekend, making exactly these arguments. Their core point? The affidavit was carefully worded. Trump stated he had no direct involvement in negotiating the specific terms. And they argue, not without some basis, that signing an authorization document is legally different from personally. Negotiating the terms of a deal, you can sign off on something without knowing every detail of how the numbers were arrived at. It's a technical argument. It's word parsing. But here's the uncomfortable truth. Word parsing is exactly how legal cases get won and lost. Precision matters in affidavits. It matters in court. And if their argument holds up, if the judge concludes that no direct involvement in negotiations is technically distinguishable from signing the final authorization, then this case looks very different by Friday. Senator Lindsey Graham said it on Fox News Sunday. This is what they do. They take normal business practices and dress them up as crimes, lawfare against the sitting president. And look, I'm not going to tell you he's completely wrong. The selective prosecution concern is real. The political backdrop of this case is real. Both of those things can be true while also being true that the signatures exist, the emails exist, and the contradictions are documented and undeniable. That's what makes this genuinely complicated. That's why it matters to actually read the filings instead of picking a side and finding headlines that confirm it, because here's where every honest legal analyst, left, right, and center, has landed. The contradictions between the sworn statements and the authenticated records are not in dispute. Everyone agrees they exist. The only question, the one that Thursday's hearing has to answer, is whether those contradictions represent knowing, intentional perjury or corporate confusion and imprecise legal drafting. That's the question. That's all of it. And the answer has enormous consequences. Let me tell you what happened Friday afternoon at 4:47 p.m. Eastern Time, because the timeline of the last 72 hours is almost as revealing as the documents themselves. Judge Holloway's order dropped without any warning. No advance notice, no scheduled release time, just minus, there it is. 19 pages, the kind of language judges use when they're angry and being extremely careful about it. She wrote, and I want to be precise about this, that the court is deeply troubled by the apparent inconsistencies between the defendant's sworn representations and the documentary evidence. Court staff confirmed she had cleared her Friday afternoon calendar to write that order personally, not delegated, not reviewed by a clerk, and approved, written by the judge herself on a Friday after clearing everything else off her schedule. Within 90 minutes of that order dropping, the White House Communications Office issued a statement calling it a witch hunt. 3 cable news networks went to breaking coverage, and then at 11:23 p.m. on a Friday night, Trump's lead defense attorney filed an emergency motion to withdraw from the case. Let me sit with that for a moment, because that detail deserves more attention than it's getting. Attorneys don't quit cases on Friday nights. They especially don't quit high-profile federal cases involving a sitting president of the United States. And they absolutely, under almost any normal circumstances, do not attempt to quit 3 business days before a critical emergency hearing. When a lawyer files a motion to withdraw that fast, that late, with that little time remaining before a major proceeding, they are not making a strategic decision. They are trying to get out of the room before the room catches fire. And Judge Holloway, she denied it. Saturday morning, 67 words. The entire order was 67 words. Motion denied. Your representation continues through the March 12th proceeding. The court expects all parties and all counsel to appear prepared to address the matters raised in the March 6th order. Translation. Stripped of all legal language, you signed those filings. You're not going anywhere. You will be in that courtroom on Thursday, and you will explain this. Think about what that means. A federal judge is holding Trump's own attorneys in place, legally preventing them from leaving, specifically because she needs them present to answer questions about what they knew before they submitted sworn statements on his behalf. That's not routine. That's a judge who has already formed a view about what happened and wants testimony from the people responsible. Now, while everyone was focused on Trump's reaction, the Truth Social posts, the 7 posts and 2 hours Saturday morning calling the judge corrupt, calling it a witch hunt, the White House press briefing, the rally language, something else happened. Something that got almost no coverage. Sunday night at 9:14 p.m., a separate filing appeared on the court docket. Plaintiffs' counsel filed a motion for judicial notice. They're asking the court to officially recognize 3 additional documents not previously filed publicly, banking records from a Cayman Islands subsidiary, wire transfers, matching the exact transactions that Trump swore under oath he knew nothing about, with his name on the account. A Cayman Islands account bearing Trump's name connected to the specific deals he denied knowing anything about. That's what's now sitting before Judge Holloway, waiting for a ruling. And if she grants that motion, if those Cayman Islands banking records become part of Thursday's proceeding, the $127 million question doesn't just get harder to answer. It may become nearly impossible. Trump's team has until Wednesday at 5 p.m. to respond to that motion. If they don't respond, the court can treat those records as uncontested. If they do respond, they have to explain. Under the eyes of a federal judge who has already called their previous statements materially false, why the president's name appears on an offshore account connected to transactions he swore he knew nothing about. There is no good option on that menu. There's only less bad and much worse. And here's something that's been nagging at me since I first read through these documents. This wasn't supposed to happen. This wasn't some ambush. The documents that are now blowing up Trump's defense, they were produced by Trump's own company during discovery. His team had them. They had them the whole time. Someone even said during a deposition last month on the record that they flagged the inconsistency to counsel. They flagged it and were told it had been addressed. Apparently, addressed didn't mean corrected. It meant filed anyway and hoped nobody noticed. But here's the brutal reality of federal court that is very different from political messaging. In politics, you say something, the news cycle moves on in 48 hours. And nobody systematically fact-checks every single claim. It works often enough that it becomes a strategy. Deny first, deal with contradictions later, assume the volume of information overwhelms the process, flood the zone. That strategy does not work in federal court. It cannot work in federal court because opposing counsel's entire job, literally their entire professional purpose in that proceeding, is to cross-reference everything. Every document gets cataloged, every signature gets authenticated, every sworn statement gets compared against every exhibit in discovery, and federal judges have law clerks, recent law, school graduates, brilliant and meticulous, whose entire day is reading filings and flagging inconsistencies. Judge Holloway's chambers has 4 of them. Friday's 19-page order cites 14 specific exhibits. Someone did their homework, someone read every page, and what they found is now sitting in the public record with a hearing date attached to it. Now let me bring in what the actual legal experts, the people who have spent careers in these courtrooms, are saying, because this isn't just commentary, this is professional consensus. Barbara McQuaid spent 17 years as a federal prosecutor and served as U.S. Attorney for the Eastern District of Michigan. Her analysis: when a federal judge uses the phrase materially false in a written order, she is signaling that a perjury referral is actively on the table. That language is not accidental. Judges who use that phrase know exactly what they're doing. And when the subject of that language is a sitting president of the United States, every single word in that order has been weighed 10 times over before it was published. Ellie Honig, former assistant U.S. Attorney for the Southern District of New York and the same district where this case is being heard, the withdrawal attempt tells you everything you need to know about what defense counsel sees coming. They see it, they want distance, and the judge saying no means she needs their testimony about what they knew and when they knew it. Read between those lines carefully, because what Honig is saying is that this might not stay civil. It might not stay a civil fraud case with monetary sanctions. It might become something else. Even Jonathan Turley, George Washington University law professor, a man who has defended Trump on multiple occasions and continues to do so on various legal matters. Even Turley acknowledged this week that the evidentiary record in this case creates significant legal exposure. Whether it crosses into criminal territory depends on Thursday, but the civil liability question, he said, is largely settled. When someone who frequently defends you says the civil case is largely settled, pay attention. And here's where the legal analyst consensus lands. Left, right, center. Pro-Trump, anti-Trump, doesn't matter. The contradictions are documented. They are undeniable. The remaining question is intent. Did Trump knowingly lie under oath, or was this a case of corporate confusion, imprecise language, and overworked attorneys who didn't fully reconcile the affidavit against the discovery record? Thursday's hearing is specifically designed to answer that question, and the answer will determine whether this stays in civil court or goes somewhere much more serious. Noam Eisen, former White House ethics czar under President Obama, laid out 3 possible outcomes. 1, the court accepts some version of the defense explanation, determines the contradictions were unintentional or immaterial, and issues minimal sanctions. A fine, a reprimand, something manageable. 2, the court issues substantial monetary sanctions against Trump's legal team under Rule 11, which governs knowingly false or frivolous filings and refers the attorneys to the state bar's disciplinary board. 3, the court refers the matter to the U.S. Attorney's Office for a potential perjury investigation. And Eisen was direct about what option 3 means. With a sitting president as a subject, it immediately triggers a constitutional crisis conversation. Not eventually, immediately. Harry Litman, former Deputy Assistant Attorney General, said something that stuck with me. He said, option 3 is rare, but so is a federal judge clearing her calendar on a Friday afternoon to write a 19-page order explicitly calling out false sworn statements by a sitting president. We are, he said, in territory that doesn't have a clear map. That's where the professionals land. Nobody is saying a conviction is certain. Nobody is claiming this is already over. But everybody, and I mean everybody, regardless of their politics, is saying that Thursday matters enormously, and that whatever happens in that courtroom at 9 a.m. on March 12th will reverberate through the American legal system for years. Now let me talk about why this matters to you, personally, directly, not as a political observer, as someone who lives in this country and interacts with its legal system. If you hold any investments connected to Trump-affiliated businesses, and millions of Americans do, through mutual funds, pension funds, various financial instruments that touch media or real estate, pay attention to what's happening right now. Truth Social's parent company dropped 11% Monday morning. DJT stock opened at its lowest point since October. That is not political commentary. That is the market pricing in legal exposure involving a sitting president. Markets don't care about your political preference. They care about risk. And right now they're seeing risk. But the bigger issue, the one that really should concern every single person watching this, is precedent. Think about what courts actually are. They're the place where disputes between ordinary people get resolved. Contract disputes, insurance claims, injury cases, business conflicts, custody battles, neighbor disagreements, everything that can't be resolved between 2 people gets brought to a court. And the whole system runs on one foundational assumption, that sworn statements mean something. That when you sign an affidavit and swear under penalty of perjury that something is true, and it turns out to be false, there are real and serious consequences. That's the load-bearing wall of the entire structure. Let me give you a real example. You're in a car accident. There's a dispute with the other driver's insurance company. You sign an affidavit saying you weren't on your phone at the time of the accident, but your cell records show activity during those exact minutes, under the legal precedent being shaped right now in real time this week. That's not a minor discrepancy. That could be perjury, and courts across this country will be watching. And what Judge Holloway does with exactly that kind of contradiction applied to one of the most powerful men on earth. Here's the thing nobody wants to say out loud, but everybody needs to hear. If a sitting president can submit a sworn statement that is directly contradicted by authenticated documentary evidence, his own signatures, his own emails, his own company's records, and face minimal or no real consequences, then the message sent to every future litigant in every future case is loud and clear. The oath doesn't mean the same thing for everyone. And once that message is sent, it cannot be unsent. The other side's attorney in your future legal dispute will cite this case. Whatever happens Thursday determines what they can argue. It determines the playing field for every ordinary person who ends up in a courtroom after this. That is not hyperbole. That is not fear-mongering. That is how the legal system works. Real estate developers across New York are already adjusting how they document executive signatures on transaction records. 3 major firms issued internal compliance guidance this week requiring additional verification layers before executive sign-offs. Banking sources say this will affect institutional financing practices within 18 months. This is already moving. The ripples are already spreading. Now let me tell you what I'm watching between now and Thursday, because the 72 hours in front of us are just as important as the 72 hours that already passed. Wednesday, March 11th at 5 p.m. Eastern, that's the deadline for Trump's team to respond to the Cayman Islands banking records motion. What they file or don't file is enormously revealing. If they don't respond, the court treats those records as uncontested and they become part of Thursday's proceeding with no pushback on the record. If they do respond, they have to put in writing their explanation for why a Cayman Islands account bearing Trump's name is connected to transactions he denied knowing anything about. Either path is treacherous. Thursday, March 12th, 9 a.m., and the emergency evidentiary proceeding begins. Note that time. The hearing was originally scheduled for 10 a.m. after Trump's team filed their 3 one-page Saturday night response arguing technical distinctions between signing documents and negotiating terms. Judge Holloway moved the hearing an hour earlier. 1 hour doesn't sound like much, but judges don't move hearings earlier for no reason. Earlier start means more time scheduled. More time means more issues to address. More issues means that 3 one-page technical argument did not satisfy her. She has more ground to cover than she originally planned. Friday, March 13th, possible ruling window. It could come from the bench Thursday afternoon. It could come Friday in written form. We don't know yet. What we do know is that if Trump or any of his attorneys are required to testify under oath at Thursday's hearing, and everything about the way this proceeding has been scheduled points in that direction, and then whatever they say becomes the permanent record. And once you're on the record in a federal proceeding, you are locked in. You can't walk it back. You can't post on Truth Social and reframe it. It exists, it's real, and it will be cited, quoted, and referenced for as long as this case continues. Here are the things we still don't know. We don't fully know what Trump's attorneys knew before they submitted that affidavit, or what exactly happened after that. VP flagged the inconsistency and was told it had been addressed. We don't know why attorneys operating at this level, experienced federal litigators who have handled high-profile cases, would file a sworn affidavit that the discovery record directly contradicts. Either they didn't reconcile the affidavit against the discovery materials, which is malpractice, or they knew about the contradictions and made a calculated decision that the risk of submitting the affidavit anyway was acceptable. Neither of those explanations makes any sense at this level. Neither of them has a comfortable resolution. And on Thursday, someone in that courtroom is going to have to provide one. I want to be honest with you. I've read Trump's response. I've read the filings. I've read the judge's order. I've sat with all of it. And there is a gap, a real documented, authenticated gap between what was sworn under oath and what the evidence shows. How that gap gets explained will determine whether this becomes a historical footnote or a constitutional turning point. I haven't decided what I think the outcome will be. The judge hasn't decided. The lawyers are still filing. The clock is still ticking. But here's what I know for certain. The signatures are real. The emails are real. The judge's language is real. And a federal judge who cleared her calendar wrote a 9-page order herself, denied her attorney's motion to leave, moved a hearing to an earlier start time, and is now potentially reviewing Cayman Islands banking records, that judge is not performing for cameras. There are no cameras in that courtroom. Nobody's getting applause in there. And she is doing this because the documents in front of her require it. Wednesday's filing deadline tells us how Thursday starts. Thursday's testimony tells us how the rest of this goes. And wherever it goes, I will be here. Documents open, reading every page, giving you what the filings actually say instead. Of what someone's communications office needs you to believe, they say, subscribe, turn on notifications, not because I'm asking for the algorithm, though, honestly, yes, that too, but because when that ruling drops, you deserve to understand what it actually means. Not the partisan spin, not the Twitter reaction. The actual legal significance of what a federal judge decided to do about a sitting president who submitted sworn statements that his own documents say aren't true. The clock is running 48 hours to the response deadline, 72 hours to the hearing. Whatever Trump's team files Wednesday or deliberately doesn't file shapes what Thursday looks like, and Thursday shapes everything that comes after it. This is the story, not the noise around it, not the Truth Social posts, not the press briefings, not the cable news panels yelling at each other. This, the documents, the signatures. The emails. The judge who cleared her Friday afternoon to write 19 pages by hand and then showed up Saturday morning to deny the exit motion in 67 words. And that's the story. That's what matters. Thursday, March 12th, 9 a.m. I'll be watching and I'll see you right here when it breaks.